Hello, my name is Gary Juskowiak, and I'm an attorney at Birch, Stewart, Kolasch Birch. I specialize in prosecution of chemical, biotechnology, and pharmaceutical patent applications. Today, I'm speaking about the Federal Circuit decision of UCB Incorporated versus Yeda Research and Development Company, decided on September 8, 2016. In this decision, the Federal Circuit held that prosecution history estoppel may apply to unamended claims after their dependent claims are canceled. Prosecution history estoppel traditionally applies to subject matter canceled from the claim itself. Although the court asserted that this holding was already encompassed within the definition of prosecution history estoppel, this holding could arguably be interpreted as expanding the scope of prosecution history estoppel. The 923 patent assigned to Yetta disclosed the first monoclonal antibodies to tumor necrosis factor alpha. This was an important development because isolated TNF-alpha is used as an immunostimulant, and TNF-alpha is a target for monoclonal antibodies in order to suppress the immune system. Independent Claim 1 includes a monoclonal antibody which specifically binds a human cytotoxin, and in Claim 1, cytotoxin is characterized as TNF-alpha. The accused infringement was the drug Cimziar by UCB, which is a humanized and pegylated monoclonal antibody fragment to TNF-alpha. Cimziar accrued $1.08 billion in sales in 2015. The issue is, does monoclonal antibody in the 923 patent encompass chimeric or humanized antibodies under the doctrine of equivalence? When a claim is not literally infringed, it can still be infringed under the doctrine of equivalence. However, prosecution history estoppel serves as a legal limitation on the range of equivalence available to a patentee. The analysis for prosecution history estoppel is whether 1. There is a narrowing amendment, 2. The rationale for this amendment, 3. The scope of the surrendered subject matter, and 4. Whether the equivalent would have been unforeseeable. Yetta successfully argued during prosecution that monoclonal antibody in the independent claims encompasses chimeric and humanized antibody. But they went further. Under the independent claims to monoclonal antibodies, Yetta added dependent claims to chimeric antibodies and argued that the term chimeric encompassed both chimeric and humanized antibodies. Yetta canceled these dependent claims after they were rejected for lack of written description. First, the Federal Circuit concluded that there was no literal infringement. Second, the Federal Circuit concluded that canceling these dependent claims was a narrowing amendment to monoclonal antibodies in the independent claims. Further, Yetta did not prevail on any of the subsequent 3 steps to overcome prosecution history estoppel. Although monoclonal antibody in the 923 patent did not encompass chimeric or humanized antibodies under the doctrine of equivalence, and Cimziar did not infringe the 923 patent. This is a very important case that elicits the strategic question, when should you add dependent claims to try and capture new developments and embodiments in the field through literal infringement, and when should you instead not add dependent claims and rely on the doctrine of equivalence? Thank you for joining me. Please stay tuned to bskb.com for more upcoming videos on interesting cases and other commentary on intellectual property.